Calificas para ser legal, ¿quieres saber? Solo llama al abogado Andrés Mejer.
Hi, my name is Andrés Mejer. Welcome to this episode of Para Ser Legal in English. Today we're going to be talking about three subjects. We always try to talk about three in different segments. One is immigration in the news, immigrants in the news, subjects that are relevant to you. Secondly, we believe that educated clients are our best clients. For that reason, we always have an education segment where we're trying to teach you something that might be relevant to your path to get legal status. And third, we're going to give you a case study, a real life story, a client that we helped, what happened, how it happened, and how it can affect you. So today in our news segment, we're going to talk about how deported parents may lose their kids to adoption, when that happens, how it happens, particularly in the context of Trump's zero-tolerance family separation policy that he had in 2018. Secondly, we're going to talk about unaccompanied minors. Who are they? What's an unaccompanied minor? And what are their options? And lastly, we're going to talk about two sisters who were unaccompanied minors and how they were able to achieve legal status in the United States. So coming back to here we are now in our news segment for the day, deported parents and how they may lose their kids to adoption. So the zero tolerance crackdown, which ended in June, separated hundreds of kids from their parents, actually thousands. But there are still today, in 2019, hundreds of kids that remain in detention, that remain detained or in shelters or in foster care and not with their parents. U.S. officials have also said that over 200 kids are eligible for reunification, meaning parents are bad people or parents are dead. It's usually bad people, not dead, but one of the parents may have passed away and the other one may be a criminal and poses a danger to their kids. And for those reasons, they won't reunify. And who's a danger and who is it and who gets to decide is something that we're going to be talking about specifically on this segment in conjunction with Alexa and her mom. Now, here in the United States, we have 50 different states. Which means in some cases 50 different sets of laws. Immigration is federal. So if a child is separated from her parents and they're both put in removal proceedings, the Office of Refugee and Resettlement is the one who has Office of Refugee and Resettlement is part of Department of Homeland Security and Health and Human Services. Health and Human Services. They're the agency that's charged with maintaining and making sure these kids are in a safe environment. So one of the conditions by which the Office of Refugee Resettlement under the Office of Health and Human Services, one of the conditions by which that they give custody to foster care parents, in whatever term you want to use custody, at the end of the day, the agency is saying, here, take care of these kids. We'll pay you for it, but take care of these kids. One of the conditions is those parents cannot file and cannot receive guardianships or cannot adopt the kids. They sign that agreement under federal law. They understand it. But like I said, 50 different states, 50 different laws, and a state judge may not know that federal requirement. And that's what happened with Alexa. So today she's 5 years old. She was separated from her mom for half of her life, 2.5 years. And it took a judge less than 30 minutes to decide that foster parents Sherry and Corey Barr would become Alexa's guardians and that her mother would be a danger to her. Now, here's very important. Neither mother nor her attorney were even notified of the proceedings. So she was detained. She was fighting deportation. She had no idea that someone was trying to take her daughter away from her. Now, that doesn't happen in New Jersey. That cannot happen in New Jersey because there's a requirement that you notify the parents or you made a diligent effort to do so, and the judge really takes a hard stance as to what a diligent effort is. You can't just say, I called them and left a message. You really have to put in detail all the steps that you did. Otherwise, the judge doesn't have jurisdiction to hear the case. Now, the bar said that Alexa's mom, the foster parents, said that Alexa's mom was abusive, she was a criminal, and she'd be a danger to Alexa. And the judge felt that that was sufficient and approved the guardianship. Now, no matter the bar's intentions, and I firmly believe that they had good intentions, they really thought that Alexa was in danger. But the point is, they should never have been able to get that far. So in Missouri, there was a couple that was allowed to adopt a baby whose Guatemalan mother was picked up by ICE in a raid. She fought for 7 years and ultimately lost. The foster couple were able to legally adopt that child, despite the requirements that they not do so under the Office of Refugee and Resettlement policy that they signed, that they knew of and that they signed. Now, we don't have all the details. What's important is, in at least one situation, it happened, but it's not the only one. There was another case in Nebraska where a Guatemalan mother, also a Guatemalan mother, got her kids back after a 5-year legal battle. 5 years and over $1 million in legal services. Now, most of that was donated by a pro bono attorney, but the point is, it cost $1 million and 5 years to get her child back. Now, Alexa's mom was a victim of domestic violence. She had 5 kids. Alexa was the youngest. Her father was abusive. I mean, physically so bad so that Alexa's mom had a permanent mark and a dent in her forehead from the hits that she received from her father. And the abuse got much worse when Alexa's dad found another woman. It became much more violent. She was hospitalized on more than one occasion. When she had enough, she filed for divorce and she asked for custody. And Alexa's father went to the police and made false charges that Alexa's mom was, in essence, prostituting her kids for sex and for money. Now, those charges were false. They were not substantiated. Neither the judge nor the police took it beyond a report. But that report was the basis by which, when Alexa and her mother came into the United States, Alexa's mom was considered a criminal. Alexa was separated from her mom and treated as an unaccompanied minor because mom was considered a criminal. Now, that was only an allegation. There wasn't even a conviction. There was never a conviction. But it was enough to separate. And that was the basis by which the bars said mom was abusive. Look, she's prostituting her kids. You can't send this child back. We want her. We'll take care of her. We'll love her. And it took the judge 28 minutes to agree. Now, mom was ultimately deported. Why? Simple reason is she didn't have an attorney. It's just that simple. She had a damn good case for asylum, particularly the time that she had filed. There was past persecution, lots of evidence. It was reported, hospital records, police reports, third-party witnesses. You know, Alexa's dad was a bad guy, period. And she had legitimate fear to go back, and yet she was deported. Now, 80% of people who are deported do not have an attorney. Now, it doesn't mean just because you have an attorney, your case is going to be granted. No, because 14% of those that are deported also have an attorney, and still they were deported. So who your attorney is also matters, but on top of it, your facts matter. You know, if you're lying, if you're not found credible, if you can't prove anything, if you don't make a good witness because, you know, you keep on getting your dates and your times confused, you're going to have a problem with or without an attorney. But it doesn't change the fact that 80% without an attorney get deported, only 14% with an attorney get deported. That's a huge difference. So if you can, find yourself an attorney. But the point of it is, Alexa's mom was deported. It took 2.5 years until they were reunited. Now, when and how they were reunited, it's because Alexa's mom took to social media, took to Facebook, and it went viral. Her government got involved. A lot of agencies in the Chicago area became involved to help her to reunite her with her daughter. And when Alexa came back, she didn't necessarily recognize her mom. She didn't speak Spanish anymore. She had to relearn Spanish. And she was constantly asking, when am I going back home? And home was with the bars, where she had been for the past 2 years. Sad story, but happy ending at the end, although unfortunately they were reunited in El Salvador, which is not the best country in the world to be, rather than here in the United States. So if you find yourself in removal proceedings, make sure you get the advice of an attorney. Do yourself a favor. Give yourself the best shot going forward. So education. This is the second segment of this segment. And we believe that educated clients are the best clients. Now, today, I'm going to talk to you about unaccompanied minor. Alexa was considered an unaccompanied minor. So what is an unaccompanied minor? It's somebody who's under 18 years when they arrive, and they arrive without a parent or a legal guardian, and they have no legal status. Now, remember, Alexa came with her mom. She was 2.5 years old when she came. But because her mom was considered a criminal based on a false allegation, she was treated as an unaccompanied minor because mom was not deemed worthy or able to take care of child. Now, the accusations were horrific, but they weren't true. An accusation is very different than a conviction. Now, what are some of the benefits? Well, if I'm an unaccompanied minor, I'm not going to be detained very long. I'm going to be released through the Office of Refugee and Resettlement, either to foster care or to a friend or family member, someone. I am not limited by the 1-year deadline to file asylum from when I entered, and I'll explain what that is in a moment. And I can file affirmatively. What does that mean? It means even though I'm in removal proceedings, I can request that the asylum office hear my case, close my deportation, my removal proceedings, and if the asylum officer finds that I meet the criteria, will give me asylum. If the officer denies me, then I get a second opportunity in front of a judge, and then they reopen removal proceedings. So there's some good options for it to be treated as an unaccompanied minor. Now, what kind of relief do unaccompanied minors typically apply for? There's usually the most common ones that are 3. It's asylum, a T visa, and special immigrant juvenile. Now, asylum, special immigrant juvenile, we've discussed at length in prior programming, but let's refresh for those that don't recall or didn't see it. For asylum, I need to show that I fear persecution. I have a well-founded fear of persecution. It can't just be that, you know what, I haven't been in my country 20 years and I don't know what I'm going to find. That ain't it. It has to be I was previously persecuted, or I have a really good reason to believe that I will be if I go back, number 1. Number 2, I have to be afraid of either the government who's going to persecute me or a group that the government can't control, like a criminal organization. And 3, I need to show why I'm going to be persecuted by the government or a group. And it has to be for a protected reason. There are 5: race, religion, nationality, political opinion, or particular social group. It has to be one of those 5. I can't just say, well, I'm Mexican, and if I go back, the criminal organizations will extort me for money because they'll find out that I came from the U.S. That ain't enough. Every single Mexican can say that. You need to show why your situation is different than everybody else and why you, in particular, have a good reason to be afraid. Again, because something bad happened to me already. So I was attacked. I just had an interview with somebody just yesterday where He was attacked by a criminal organization, MS-18. He was shot, and he has horrible scars up and down his arm from the bullet that almost killed him. He almost lost his arm, and he was attacked the second guy, and they cracked his skull, and he has a big scar in his head. Now, he still needs to show what was the reason why he was attacked. Was it race, religion, nationality, political opinion, particular social group? But he can show past persecution. So it's likely if they attacked him once, they attacked him a second time. Now, they also killed his brother. So if he can document the reason, he has a solid claim for either asylum or something like asylum, because there are at least 5 different kinds of asylum depending on certain circumstances. So we'll just call them all asylum in the general sense. Second thing unaccompanied minor can apply for is the T visa. T visa means victims of trafficking. Could be sex trafficking, could be labor, like indentured servitude type of trafficking. But you have to show that you were a victim of that. You need to show that you assisted law enforcement, meaning that usually the police, but it doesn't have to be. It could be the DEA, it could be the FBI, it could be a variety of different governmental organizations, but an organization that has authority to investigate the crime in which you were a victim of, so that you help them either to investigate or you help them in the prosecution. Meaning, if you were asked to testify, you showed up. If they called you to court, you showed up. You can't just ignore it. And that you suffered extreme hardship if removed from the U.S. Now, extreme hardship is a known standard. It's the standard for almost all waivers, but in those waivers, you're showing how someone else will suffer extreme hardship, how your parent, how your spouse, how your child, who is a U.S. citizen or green card holder, will meet that standard. Here, you just need to show how you will suffer extreme hardship if you are deported back to your home country. T visa, you get status for 4 years. There's waivers that are included. After those 4 years, you can apply to become a green card holder. Once you've had that for 5 years, you can apply to be a U.S. citizen. So it's a really good way to change your status if you meet the criteria. Third option is special immigrant juvenile. Now, we've spoken about that in the past. Special immigrant juvenile is a great way for some kids. Doesn't help everybody, but it does help some. There are 3 different stages. We're going to talk a little bit in more detail about this because our case example, we're going to talk about Maria and Anna and how those 2 sisters were able to get special immigrant juvenile status and were able to get to stay in the United States. Now, there are 3 steps. The first is in New Jersey, you need to have a trial in front of a family court judge where that judge has to make specific findings. He or she that has to make a finding 5 things. 1, you're over 21. I'm sorry, you're under 21. If you're over 21, you don't qualify. So you have to be a minor under 21. Secondly, you're not married, because if you are, you're independent. It's like being considered over 21. So you're not married. Third, you're dependent on somebody. It could be a parent, it could be a family friend, or it could be the courts. You need someone to help you in some fashion. 4, you can't be reunited with one or both of your parents because it is one or both of your parents who abandoned you, abused you, mistreated you in some fashion. That's usually the hardest part. Last is, it's not in your interest to be returned to your country. Now, big difference if you're from Spain than if you're from El Salvador. Country conditions matter. Options in that country matter. Crime in that country matter. But it's case specific. What happened to you in Spain that would cause you, that doesn't give you a good option? Well, let's, for example, say that there's a recession, there's 20% unemployment, there's inflation, there's no jobs, there's high crime. So again, that's not actually what's going on in Spain, but my point is, even in a westernized country, there can be conditions where it's not to your interest to return. Think of what was happening in Greece. Think of the situation in Italy now. So, every country is different. Every case is different. You have to focus on your situation. Once the judge makes his or her special findings, you then have to apply to immigration and say, please recognize this decision by the judge. Now that's weird. Why are we asking immigration to recognize the decision by a judge? Because special immigrant juvenile is a federal program. But here we have a state judge making findings, and now we're asking that federal agency, USCIS, apply those findings. Why does that happen? Because there is no federal court for family law or for juveniles. There's criminal, there's tax, there's civil cases, but there's no family cases. Family court cases are decided on a state level. So here we have a federal statute giving a state judge authority to make factual decisions by which immigration will then review and then determine pursuant to its statute. So judge just makes those 5 findings, and immigration has the final say whether they grant him or her special immigrant juvenile status. Once that happens, you need to wait for a visa to become available. Typically, it's 1 to 2 years, but it can be as much as 3. You then can apply to become a lawful permanent resident. Once you've become a lawful permanent resident or green card holder for a year, you can apply and be a U.S. citizen. Important caveat, if you get your green card as a special immigrant juvenile, you will never be able to apply for either parent. They want to avoid the scenario where husband and wife commit some fraud, make certain allegations, give the child a green card, then the child applies for one parent, then the parent applies for the other parent, and all of a sudden you have the abused person, the abuser, who was the cause of the abuse and resulted in child getting a green card, also getting a green card based in part on that conduct. That's a big no-no, and that's what they're looking to avoid. So unaccompanied minors, 3 common ways in which they would achieve legal status: asylum, T visa, and special immigrant juvenile. U visa, they can also apply, but it's less common because they have to be in the United States. The crime had to have occurred in the United States, and typically we're looking at a situation where a minor is here for less than a year. It's not common that they're a victim of crime, but think of the trafficking scenario. If the trafficking likely happened in the United States, that also could have been filed as a U visa. Although it's harder, there are the requirements, it is possible. So thank you for listening to our education segment. I hope you're better informed about what an unaccompanied minor is. And now, in our case study, I want to show you an example of how we applied a special immigrant juvenile status to get legal status to 2 unaccompanied minors. We'll just call them Maria and Anna. Facts are accurate, names are not. So here are 2 sisters. Father was a drunk, father was abusive, but he abandoned them. They have no contact with dad. As far as they recall, they can't even remember what dad looks like. Now, Maria, who was older, she has some memory of dad because she was about 4 or 5 when he left. Anna was 1, and she has no memory of dad. So came in, they were minors, they were alone. Mom was here already in the U.S. Mom filed for custody in the family court, had to notify dad. Now that was interesting because they haven't seen or heard dad in over 20 years. So they used the last known address of where dad was. And it was a challenge to get jurisdiction on him, but ultimately the judge granted it. They testified. There was a trial by which Mom, Maria, and Anna all testified and proved that they were under 21, that they were single, that Maria and Anna were dependent on Mom, that they were abandoned by dad, who doesn't help them in any way, and also he was abusive before he abandoned them. He was a drunk, and when he drank, when he got drunk, he became really violent, and that was the reason why they separated, and they've had no contact ever since. And that it was in Maria and Anna's best interest to stay in the U.S. and not go back to their home country. So that part normally is the easy part. But here, I mean, granted, it is a trial, but it's a trial where there isn't an attorney on the other side that's trying to poke holes in your case. If you're filing for asylum and you're in front of an immigration judge, well, the government is going to have an attorney. And that attorney is going to try to show that your facts are inconsistent, that what you're saying today differs from what you said in other occasions. We'll try to say that, listen, okay, so maybe something bad might have happened to you in this part of the country, but there's nothing to prevent you to move to another city or another state and start over, and then you'll be fine. You don't have that opposing point of view, who some are more effective than others, but it doesn't change the fact that they're out to get you. In the family court setting, in a special immigrant juvenile, that usually doesn't happen because the other parent usually doesn't show up. Now, they can show up and they can bring an attorney and they can try to fight and argue and say that what you're saying is not true, that he wasn't a drunk, it really was a good guy, even though he hasn't seen the kids for 20 years. It's a hard case to make. But on some occasions, it happens. Now, here the problem was compounded because the judge that made her initial findings retired. So, and the judge's order, well, when the judge signed the order, judge created an addendum. And in that addendum, she only referenced the older sister, didn't reference the younger sister. So we didn't initially catch that. It was filed with immigration. The judge sent the addendum after the fact. We had to file urgently because the older daughter, Maria, was going to turn 21. And it had to be filed before she turned 21. So it was filed literally within days before. And then when the judge provided the order, we forwarded it. And the older daughter was approved. The younger daughter was not initially, because the mistake that the judge made only included the addendum on one sister. And so, okay, we reapplied to the court to fix it. Problem is that judge had retired. And the judge that now heard special immigrant juvenile cases was not the judge that heard the testimony and made the decision. So we need to have a new audience. We needed to notify dad again. We need to go through that whole process, to make that judge comfortable that Anna did meet all the requirements. We did it, and the judge signed it, and we submitted it to immigration, and immigration ultimately approved it, and Anna now also has special immigrant juvenile status. Maria has had it for almost 3 years, and she's about the point now where she can file for her green card. Anna's had it for less than that, so she can't yet file for it. The priority date is not yet current for her to apply for her green card, but she will. In 5 years after that, they will be able to be U.S. citizens. Now, Anna is also about to get married to a U.S. citizen, but that doesn't matter, and she doesn't need her spouse to apply for her because as a special immigrant juvenile, she can adjust that way. Now, if she had just gotten special immigrant juvenile status and she didn't want to wait 3 years, and she's now married to a U.S. citizen, well, in those narrow circumstances, her spouse can apply for her and she'll adjust quicker. But again, it's more expensive. In most cases that will take longer, and it's probably unnecessary, but every case is different. And you have to evaluate every case on its own merits. So special immigrant juvenile is a good situation for many, for the reasons I explained before. The family court setting is a more controlled setting. It's a faster setting. You're not going to wait a year. In New Jersey, it might take 2 or 3 months before you get your date. Now, sometimes it takes longer because getting notice on the parent who's abandoned or abused or mistreated, well, that could be harder because he or she may not even be in the United States. So that makes it much harder to actually get that notice to that individual in a way that the court rules and the judge concedes meets those requirements. If not, the judge doesn't have jurisdiction and the decision is invalid. And we definitely don't want that. So for many, special immigrant juvenile is a good situation. But again, it's not as good as a U visa, for example, because a U visa can help the whole family. Special immigrant juvenile only helps the kids, can never benefit the adults. So we typically look for a scenario that helps everybody. U visa is one that comes to mind. T visa is another. Asylum could as well, because if the kids file for asylum and they get it, well, parents can also be included, depending on the age of the kids. Parents may not get asylum and may get withholding of removal, but again, one petition, one hearing, one trial, and then you tag on the other family relatives who maybe didn't have the same risk as the child because they were not then in removal proceedings. So every case is unique. You got to look at the situation. It is complicated, but for many, special Olympic juvenile is the best option. It was for Maria and Anna, and they're much happier for having had that opportunity. So thank you very much for listening to this segment. I hope you found it helpful. In the first part, we talked about how deported parents may lose their kids through adoption. Secondly, we talked about what is an unaccompanied minor and
Calificas para ser legal, ¿quieres saber? Solo llama al abogado Andrés Mejer.